I hear there's really good news. The order that had the page of my order that had the error on it, none of y'all have. It was divine intervention. And so apparently it's going to be emailed to you. I can't tell you how happy I am about that. So I will look carefully, and all of my staff will proofread my document so it will hopefully be accurate. So, welcome back.
Okay, we'll pick it back up now where we left off. We were talking about when we stopped the public inspection of files and records. We kind of alluded to this a little bit before. The general public shall be allowed to inspect the following records: records of juvenile traffic offenses, any complaint, petition, or order from any case that was open to the general public except deprivation proceedings. Okay, that's a big exception there. Or any court files and records of proceedings involving legitimation, or records related to a charge of delinquency transferred for criminal prosecution. Now, the Act does not address the issue of making copies or files of those records, okay? But the important point for us here is that deprivation proceeding records are not open to the public, which is what we were talking to earlier. And I think, you know, once again, it was very specific, about what you could get, complaint, petition, or order. But the deprivation proceedings are taken out. So once again, back to our issue a minute ago, was when they come and ask for that order, can they get it? I don't believe you can. I don't believe you can. And Judge Tilly was saying, you know, that if it was open, you could at least communicate that what happens. Is that what you were basically saying?
Yeah, I think, you know, the downside, unfortunately, is for people who are not parties. I mean, we had the group, you have a watchdog group that wants to be sure that the law is being followed. It sounds like, regrettably, they're not going to be able to get the information about why the hearing was closed if they don't know a party. So I just think that's a hole. It sounds to me like that's a hole.
Mm-hmm. It may be. I mean, it may be a hole. Maybe it's something we need to talk about, or something definitely need to talk about. I'm not sure what in that order. I mean, well, if you'd have to redact it or whatever, I mean, if you get it out, it depends on what would be in the order, you know, how specific the order was. Because I'm thinking that if you do this order close, you're going to have to make some specific findings of fact so the court could look at it. Yeah,
it requires findings of fact.
That's an interesting question. Let's talk about why that might be the case. Why the general public might not be able to inspect deprivation records. Let's just talk about why. I'm speculating a little bit. Judge Tilly and I, neither one were present for when this was talked about, and we've heard a little bit about how it kind of came about. But why do you think the public might not be able to inspect records of deprivation proceedings? Anybody have a thought about that? Yes, ma'am.
As a clerk and as a human being and a mom, I would just say for the privacy issues and for also losing paperwork, because you know how we are with our paperwork. I mean, I don't know how the Superior Court does it, having their records open and allowing people just to come and filter through them. But that would be mine. I just don't, in my opinion, I believe that the general public shouldn't be allowed to have access to the records for fear of losing them, stealing them, misplacing them, shredding them, whatever they would want to do with them.
That's a good thought. I mean, you'd have to have a staff member sit with them.
Yeah.
And that's what I wonder, because I mean, in record rooms in Superior Court, I don't think they do have anybody sitting there watching them.
Judge Hammond.
Yeah.
Oh, I'm sorry, go ahead.
I just wanted to make a comment.
Yes, ma'am.
That, in Minnesota, the records are open, and I think in Georgia we avoided that because it's a fairly expensive endeavor and it puts a lot of work on the clerk. The record, they don't let anybody look at the records till they've been redacted. Mm-hmm. And you can imagine some of these, you know, just one case that could take somebody hours to redact it. So we felt like that was probably impractical because there is so much confidential information.
Yes, that's a good point too.
Just to kind of follow up on that, I was thinking there's going to be a lot of stuff in that record that may never find its way to the actual hearing.
Yes.
So there may be all sorts of confidential information or, you know, no matter which side you're on, could be harmful to either the child or maybe even the parents, because you can put a lot of stuff in a petition, but then that may not actually turn out to have been proven at the proceeding, and yet it's out there for the world to see.
That's true.
Great point.
Those are all great points. This is just speculation, but Title 4E of the Social Security Act restricts the use of information concerning children involved in abuse and neglect cases. And if the state wishes to have that money, that federal money, they've got to protect those. So we're going to talk in a minute about how the proceeding can be open and not violate federal law, but the records still appear to be protected by that federal law. So how does that impact open deprivation proceedings? I mean, the question is, the proceeding's open, but the record's not open. So what impact does that have? And we've already kind of addressed one, I guess, about getting a copy of the order, whatever. What else do you think? Any thoughts? My thought was this. I put it in this law. I'm sorry, you got a question? I'll make my comment. The Deficit Reduction Omnibus Reconciliation Act of 2005, it clarified that you wouldn't violate Title 4E by opening the proceeding. But it's not, but the record's there's a different issue. I mean, that doesn't seem to be addressed. That was my thought. Yes, sir.
I guess I can understand why records of deprivation proceedings are not open to the general public, just for the simple fact that people are sitting in a courtroom, their memory is only so good or so short. You can always hear something and you might remember bits and parts, but having it in black and white, you can refer back to and say, hey, this is what happened on that day. So that would definitely be a no-no in terms of a lot of our clients. As a parent attorney, they're very private about their matters. So yeah, my neighbors might know that, yeah, my kids were taken by defects, but they may not know the particular reasons. So, I mean, keeping those from the general public might be another reason why.
Yeah, I mean, in civil cases, I'm not saying it's going to be the same, but in civil cases, it's not unusual for you get parties just mad with each other to start copying stuff and PDF file it and stick it up on the internet. I mean, and that could theoretically happen here and could be a really big problem. What about sealing the record? That procedure remains the same as it currently was formerly. However, the effect of there has been a removal of the prohibition against sealing a record of a case that was open. So even if a case is open to the general public, you can now petition to close that. That was put in, and it specifically permits the sealing of a record containing identifying information of a victim of a sexual offense. One of the new provisions that's kind of exciting, I think, is this information sharing mandate, which creates the new code section of 1511-84. And this was a part of it's in the bill, but it's not really directly related to the open proceedings. But the idea here is that state, county, municipal, state departments, boards, agencies, and that includes all the DJJ and mental health and Department of Human Services, all. Those will now shall exchange with each other all information not held as confidential pursuant to federal law and which relate to the child that might aid in assessment, treatment, intervention, or rehabilitation. What do you think? I mean, what do you think about this? We have a community collaborative in my circuit that kind of does this and shares information, and I find it really helpful. That they share information they have, and when I get, especially on delinquency, I get a better picture of what I'm dealing with, and I don't duplicate services a lot of times. But what do you think? Anybody have any thoughts or comments about this? This, in my opinion, this is a really good thing that came out of the law. You want to weigh in?
I think they're good. I agree. They agree.
Yeah. We don't. Yes. I'm sorry.
Is this working? No. Was there funding for this?
Shall we take a vote on whether we think that happened?
Yeah. Really? Really? Was it funny?
Thank you for that question.
There's always the hope.
We have a collaborative and we have a universal release, so we've been doing that for years, and it does work well. But the question is, what's the implementation of that for the other places? Like, how do you do that? How do you get all those people on board? I mean, the law says it. So what? I mean, how are you gonna do it? Are you just gonna say, I'm from DJJ, give me the information? Like, there's still the whole implementation piece of that everybody who doesn't already have that set up is gonna have to come to terms with it. And even though it says they shall, I mean, you're gonna have releases, you're gonna have forms, I mean, you can have agreements. Like, how are you gonna implement it? I mean, it's a wonderful, wonderful thing, but the implementation is where I think people will get confused, or if it's not addressed by all of those people in each community, how good is it until you get it it all laid out for you.
That's a great point, and I'll tell you that the places where it works the best is when you have judicial leadership that kind of calls all those stakeholders together and then, gently coerces them to see the importance of it, and not really coercion, but to see them get on board. I know like, for example, in Clayton County, Steve Teskey has the Fast Start program, which they have as community collaborative. It works great, and that's something that he took some judicial leadership to do. So that's the only answer I know, but I think you still will have some resistance from some parties there. Yes, ma'am. One second.
Yes, don't be fooled by his graphic. That's not money changing hands up there on the screen.
Sorry for that.
How are we supposed to know if we are asked for information if it is to aid in the assessment, treatment, intervention, or rehabilitation? Because motives of some are not, and I'm not saying, I know, I see one up there, but how do we know if their reasoning is for one of those?
Yeah, I think it's going to have to be done in some kind of collaborative. I think it's going to have to be in, maybe under the authority of the juvenile court or something. I don't think just anybody on the streets, I need this for that. Yeah.
Well, it's like if you're in the LIPT meeting, the local interagency planning team meeting, that'd be kind of the example of where you would do that.
Mm-hmm. Anybody else? A couple of important things about the information sharing mandate is that it shall not be utilized to assist in the prosecution of a child or utilized to the detriment of the child. Also, the release of the information does not rescind the confidential nature of the information, and it's not subject to further public disclosure. Just two important points about that. Yeah, that is in there. I think it'll help us, but we don't have all the answers surrounding that. But those places where these collaboratives do exist, I think it's just another arrow in the quiver to kind of help bolster and maybe get people convinced to get on board with sharing information. Okay, the last part of this is what I'm calling discussion points. Now, the discussion points were kind of derived before we had the law, or after it had changed, but before it had been enacted. So we've already hit on some of these, but the idea here is to stimulate discussion from you and just to get what your thoughts are. We've already talked a little bit about this one. Does open deprivation proceedings, do they violate federal law? I'll run on through this one. Well, CAPTA required near complete record confidentiality, and Title 4E requires record confidentiality. So we knew those were in place. But, when this thing first happened, those laws were in place, but some states like Oregon, they believe their Constitution requires them to open juvenile proceedings. So their question to the feds was, is this a violation of federal law, us already having open juvenile proceedings? And what happened was when CAPTA was reauthorized in 2003, it specifically allowed for states to figure out the procedure for opening that up. And I also mentioned the fact the Deficit Reduction Omnibus Reconciliation Act clarified that states could open those proceedings and not violate Title 4E. So that was kind of the clarification, but it already existed out there before that time. Now, one thing that CAPTA did require when it was open, it required that the procedure must at a minimum ensure the safety and well-being of the child, parents, and families. In my mind, that's what the ability to close kind of addresses. It provides some ability to close it if the safety, if there is an issue there. Any thoughts or comments about that one? Will open deprivation proceedings lead to greater accountability? We've already talked a little bit about this. What do you think? This is one of the major arguments for the push to open up, is this accountability. What are your thoughts?
I'm one of the former CASAs from Cobb County who's now in Better Courts for Kids, and we have worked to try to get this started. And I guess one of my real concerns is that we hoped it would be accountable for that, especially for me, for people like guardian ad litems in our county who don't bother to ever get to know their children. Some of them just don't. I've been talking to a good guardian here who does. And so we hope that would be the case, and that some watchdogs, we're not concerned about the next door neighbors coming in to see, but we did hope that some watchdogs would be able to get in just to hold some courts accountable maybe. And in that case it would be. My concern is that there seemed to be so much muddiness about what cases can be closed now, and if watchdog groups cannot know why they're closed, I don't know if it'll hold people accountable or not.
Yeah, and that's a good point. I mean, whether or not, I'm not sure you won't be able to know or not. Can you get into the record? No. But will you be able to know or find out? That's something I think we're trying. That's a good issue we brought to light today that we're going to have to think about addressing how we handle that. Because this is just me personally speaking. I mean, it doesn't do any good in my mind to not let you know why I didn't close it. But by the same token, what I tell you about why I close it might not be what you want, because I'm going to be cautious about what I let out because, it's in the record. So, but I thought, once again, I think that's a great point that we need to address.
And the watchdog groups are not trying to be nosy about kids. We really want to be more concerned for kids and make sure that somehow parents and attorneys who don't show up or don't do their job maybe get held a little more accountable for the children rather than being nosy about children.
It may be, I think what you would want to watch for are patterns of closure. And that's going to give you an idea about whether, perhaps it'll give you an idea about whether, whether things are going to be open or whether they're, and then try to get a sense, maybe from lawyers, what's the pattern looking like? Are we dealing with a court that just thinks courts ought to be closed? Are there reasons? I hope we're going to assume that courts are going to take this law seriously, that the presumption is openness, and will not just make a blanket presumption that it's in the best interest that cases be closed. But I guess we'll have to, you'll have to see how it pans out. Because if the only people being left out are watchdog groups, that's interesting.
Have you made a decision as to when you as the court need to be accountable, like that court's own motion? Have you thought about if no parties say anything or nobody brings it up? Or have you thought when you as a judge need to say, okay, nobody said anything, but what are the criteria for me going, what I need to close it? Or have you thought about that at all? Because no one's asked us anything, so it's sort of kind of been inert in that decision. But when you think...
It's going to be the same analysis. It's going to be the same analysis under that. I guess, were you saying that if I make it on my own motion to do it, I'm going to be going through the same analysis that any party would? I don't...
What's triggering you to make the thought that you need to do it on your own motion? Have you thought about what's going to make you go?
Personally, I think that it's not going to be, I'm not going to be jumping to close anything. If the parties don't want to close it, the law is open. So unless something really, unless I see a really red flag about something, I really can't put any more meat to the bone than that right now. But my position is going to be, I'm not going to be looking to be the first party closing all these things. I'm going to be very reluctant to do that.
Yeah, my thought is more like I'm going to be more inclined to keep particular individuals out.
Yeah,
that are problematic to this family, and even in the case that I was talking about earlier, where the middle school child or the late elementary school child is humiliated by what's going on, I would be inclined even in that kind of case to allow a watchdog group in, because they're completely disinterested, and we've had even in those kind of cases we've had strangers in the courtroom. We've had DFACS interns, or we've had, people that or CASA trainees, or, we don't clear the courtroom, even for the oddest kind of, or the most egregious kind of cases. It's just the humiliation factor is really based on them knowing people, not on strangers, I think. So, I'd be inclined to let watchdogs in there, even if I let nobody else in there. So, it would be more, for me, keeping people out, it would be the child molesting boyfriend that I knew was a child molester because I dealt with them 5 years ago, that kind of thing. So, and the fact is I have a lot longer longevity with the case than all these brand new attorneys that have only come in the last 5 years and don't know about that. So.
Yes, sir.
Question is, as judges, have y'all thought about what this would do to the length of y'all dockets, as far as would this cause y'all to slow hearings down to make sure all I's are dotted, T's are crossed? Because, in rural counties where a smaller volume versus, say, Fulton County, where you got like 20, 25 cases on on the docket that day, I mean, you're looking at being in court, I mean, till 8, 9, 10 o'clock at night.
Personally, I don't think it's going to change the way I do business at all. I mean, I think I've already pretty much had open court. I pretty much let the families, members that want to come in. I've been doing that for years. I mean, I don't have the general public beating at the door to come in. I don't have the press beating at the door to come in. I mean that doesn't happen. I mean, I don't think, from my perspective, just personally, it's going to change how I do business at all.
I think you might, and I think the same. I think we might have the occasional case, you know, if we have if some terrible thing happens and there gets to be notoriety on a particular case, that might happen.
Yes.
That'll be the rare occasion, and we'll just deal with it.
Let's talk a little bit about what the research, the most comprehensive study we have is the 1998 Minnesota Open Court study that was done in this area. It's not a perfect study. It has some flaws, but it is a comprehensive study. They found that a greater number of foster parents and relatives attended the hearings once they were open. So that was one good finding they had. They also reported that some court staff reported that they were more aware of policy and procedures. They were better prepared because they thought they might be subject to some kind of scrutiny. So once again, that was another good side effect from that they found. However, they also found that public participation, you know, after the law was enacted, and then there was this kind of flood of participation, and then it just fell to nothing. It went right back to normal. By way of correlation, I mean, I've asked several judges, several stakeholders from around the state, you know, how has this been an issue in your court? And, you know, zero is what I've had so far. I've had nobody tell me that this has been an issue, with the one exception of today we heard one, you know, that it's been an issue in the court. So maybe it's just too early. I mean, maybe it's too early for us to really have a good feel for this, but it is now 1 month basically into it, and it doesn't seem to have significantly impacted the way we do business. Do you have any thoughts on that? Okay. What about media participation? This is one of the things that I think concerns not just judges but also other stakeholders. Will media participation negatively affect the outcomes of deprivation proceedings? What do you think? Yes, ma'am.
This was a big issue when the legislature considered this last, February, March. There was a lot of concern that the press would get in, names would be published, and the bottom line seemed to be that a court cannot order the media not to publish names, but they would request that the media treat the juveniles the same way they treat rape victims, whose names are never published. For example, Cobb County had that big trial 2 months ago, the 12-year-old accused of murdering his infant cousin. That was juvenile court. Greg Poole handled that. It was all in the paper. Name never appeared. It was before January 1st, so the press was in the courtroom. I mean, again, they didn't publish names, and I think they handled it fairly well. But it was a case that I think the public wanted to know about and had a right to. I don't think it's going to be a problem. I think the media will follow the rape victim procedure.
My question there is, how do we know? I mean, basically you're saying it sounds like they had like a gentleman's agreement, you know, that we're not going to do it. But, you know, I mean, how do we know that? Because you're going to have the potential there for it to get out. And it's not really addressed. Yes, ma'am.
Well, and in opposition to that, I mean, that particular case is a closed case because it was a delinquent case.
But it was a homicide.
But it wasn't a 440 case because it wasn't, I mean, it might have started that way, but.
Yeah, and he was 12, so I don't think it was even
still
a DF even. So it was a presumptively closed case.
And so, you know, the media has to ask to be admitted, and then obviously Judge Poole allowed them with some restriction and could have very easily put as part of the restriction, which I've done before in delinquent cases, where you specifically say you cannot mention the child, no pictures, keep the camera right on the judge or whatever. And so you have that ability to scrutinize the information. If you're starting off with an open court, even if there is a gentleman's agreement that the media doesn't use names, there's still nothing that prohibits them under an open court.
Yeah, I mean, I think that's a good point. And we're going to talk about it in just one second. Let me flip on down a minute. The 1998 Minnesota Open Court Study found that the open courts was basically a media non-event. You know, they were interested at first, and it tapered off to nothing. So, at least in their experience, it wasn't a big issue. But I think the thing is this always prevalent under the surface, and that is, what about motive and sensationalism? I mean, what is the motive of paper? Is it to report the story accurately? We hope so. Or is it to sell papers and magazines and articles? You know, they want to make money. I mean, when does that come into it? And I think that's kind of the big thing that we're a little bit concerned about. If they're going to compete with another media outlet, they want to do it. What's going to stop them from sensationalizing the story? What do you think? What are your thoughts?
It just depends, doesn't it?
Yeah, it really does. It really does.
And I had a similar agreement. When early on in my career, there was a homicide. He was charged as an adult first, but the grand jury, instead of indicting him as a murderer, indicted as an involuntary manslaughter. So it came back to me, and so the press wanted to come in, and I said, "You can come in, but you need to stop publishing his name in the paper now because it's not even open to the public anymore. It's not even a designated felony." And they agreed to, but they asked for permission to explain why they were no longer going to use his name, and I thought that was great. They educated the public on it, and then they came in and reported on it. And so I think it does depend on your relation. In small towns, you know, you do have a relationship, hopefully, with the media. I really do wish the media would attend more often. I mean, to educate. People are always shocked when they find out what happens in juvenile court. They are shocked at what happens. You know, when people are trained as CASAs and when people are trained as panel members, you know, they are horrified. Or when they end up sitting on a grand jury and hear, you know, the aftermath of people that are charged with crimes, they are shocked about what goes on. And you do kind of wish that they knew more so that they could advocate for more resources for children and families and prevention and treatment. So we do wish that we could get all the good out of this, but none of the bad.
Right.
Gee, what a thought.
And those are the two very best. I mean, we hope that the press will take those opportunities to educate and to bring light to it. That could be a very big, very big positive in this. But we just don't know. We don't know the answer to that. The Minnesota Open Court Study, once again, was used in this. Some jurisdictions with open proceedings reported that public and the press are only interested in notorious cases, which we figured that was going to happen. But the Minnesota Open Court Study recommended that they have special training for the journals, about these cases. And that's a very good idea, but, where's that going to come from? Who's going to pay for that? Are they going to, and whether they're bound for it, those are just unknowns to the thing. Will media participation stigmatize families and hamper reunification, especially in small communities where gossip abounds? This was kind of one of mine. In a small town where this information goes, is this just going to add fuel to the fire? What do you think? Yes, ma'am.
One of the things that I've been telling a lot of people who have had questions about the new open courts is I don't know who was practicing when we opened the delinquency courts in Georgia, but it was only 10 or 15 years ago. And there was all this uproar. Judges were freaked out. The public was freaked out. Attorneys were freaked out. There was actually a number of news stories in Atlanta leading up to the day the court opened, and then nothing happened. I think one reporter showed up in Fulton, one showed up in DeKalb for a day, and that was it. And so, the public didn't show up. So perhaps there's a difference because of the type of cases, but based on sort of public interest concerns, more people seem more concerned about what's happening with juvenile crime than abuse and neglect. And if no one's showing up for those hearings, I personally don't anticipate any difference. I will say one thing that's been interesting to watch, if anyone hears from Augusta, but the Augusta Chronicle publishes on the delinquency side the names and the neighborhoods and possibly even the addresses of all the children on the delinquent side who are adjudicated delinquent, all the cases that are open. And our office has worked over the last 10 years to try and educate them. Lorianne, you might have written some of those letters, and talk to them about the rehabilitation effects of juvenile court, particularly for theft when you're 13 years old. But they publish everything they get their hands on the delinquency side.
Well, yet again, I'm glad I live in Bartow.
Anybody else want to weigh in? Yes, sir.
Couple things come to mind. One, I would suggest that the courts invite the press to come. If you think the press ought to take an interest, pick up the phone and call your feature editor of your Bartow County Times and invite them to come in. That will start the process positively. I don't think the organized media is likely to be a problem. I would think the Facebook and the social media, whatever it is, tweeters and everything else, are going to be the issue that
would be tweets.
Obviously I don't.
This is another problem.
that the sensationalism, the gossip, the getting the negative impacts, the embarrassment could be if the friends come in and then disseminate the information with somewhat ill will or juvenile mind. Could be a bigger problem out of this. I still think the balance is we're going the right direction, but I would think that's what we're going to see as the negative if it happens.
That's a good point. Good point. The Minnesota Open Court Study against monitored situation, they found generally that no member of the public that didn't have some connection to the proceeding actually even attended the hearing. So that's the vast majority. And of course, you know, I think we figured it was going to kind of be that way for the majority of time. We're just kind of worried about what might happen in those certain cases. Also, our legislation does give us the discretion to close to protect if we're really concerned about it. So that's a good thing about it. What about the possibility of creating a greater possibility for re-victimization of children? And I know we're getting close to the 4 o'clock time period, but what do you think about re-victimization? Okay. Oh, good. Okay, good. What about the possibility for re-victimization? Anybody have a thought?
And that was the one I was worried about. And I think that's where we really, I mean, we want good guardians ad litem. That's where we don't want the one that's not meeting the child or falling asleep in the courtroom. We want to be sure, because, you know, after this passed, one of my best guardians was saying, I'm going to be moving to close. And I'm trying to keep her thinking that doesn't necessarily have to be every time. And, you know, so, and nothing's happened. I mean, there have been no motions to close. So, yes.
Wait for it.
My comment on that would be whether it's kind of overt re-victimizing, is it going to make the child feel like they're re-victimized? You know, the child's kind of victimized by the whole process anyway. So whether or not it's re-victimizing them in some way that we all can see, what is the mental health impact on them?
That's the point.
Mm-hmm. Yeah, that we don't see.
Right.
Yeah, that's a good point, because I was looking around for something, and what I found was a 2005 survey of California pediatric psychologists. And they showed that this was their belief that it would lead to it would cause a severity or increase in post-traumatic stress disorder. So I think the potential is there. I don't know that we have good data on what it does, but I think those of us that work in this area have enough experience to know the potential is there to harm them. To what extent or how great or how vast it is, I don't know. And you know, by just the small sample size we have now, it really hadn't been an issue. So.
Well, and the example keeps running through my head is we have a particular high school teacher who brings his civics class to court. And traditionally, he has not been able to observe juvenile court because they're all closed. And I just can imagine that class of students in a deprivation class that involved one of their fellow students. I just wouldn't allow it. I just couldn't have it, because the re-victimization for that child would just be horrendous. Even though, I mean, these are the best students in that school, that doesn't mean they're not mean.
Yeah.
And I, you know, if nobody else raised it, I'm raising it.
There's the case, Judge
yeah,
Manson.
There's the case, you know. So
there's the case.
As much as I would want, you know, if it were an infant, you know, if there were, you know, a case of an infant, unless, you know, there were no older, I mean, I would be very careful about the potential for harm when they all are on Facebook. I mean, they really are. I mean, the Minnesota study there wasn't Facebook when the Minnesota study was working that study, so.
Right. And of course, as Judge Taylor just mentioned, that SB 207, it has that protection for us to do, to exclude and protect the child through exclusion of individuals or closing the hearing. So that's built in. Also, 2 jurisdictions, Washington and Florida, that have similar open court laws to Georgia, have once again seen little increase in public participation. So, once again, the other jurisdictions that have it, there's not a lot of data there for us to show that it's really gonna make these fears come to light. Last discussion point that I have is this, and it comes off the Better Courts for Kids website originally, and I had already talked about this with them before. The point I want to make here is this. They had this on their website, that juvenile court secrecy harms children. Okay, I know from talking to them what they mean by that. They're very well intentioned. But what I want to suggest is that with opening courts up, we need to be very careful. I mean, I think it could absolutely be great. I've pretty much had open courts for a while. And I found that getting a family, even extended family in, helps. I mean, I had a case not too long ago where I had a mother who had mental health problems, and she presented very well when she was okay, and when she didn't, she was just a mess. And she told every family member that she could think of how corrupt I was and how bad the process was. So I had about 20 family members say, "We want to come to court." And I said, "Please do, come on in." Well, they came to court, and she threw a fit. She ripped the pleadings up and, said bad things to a lawyer and stormed out of the hearing. And, well, when that thing was over, they got up and marched out and didn't say a word. They got to see what I see, So, I mean, I think it can have the potential for good. But I think the tone of the rhetoric we need to watch. Because how do people take juvenile court secrecy harms children? I think that could be open to being taken very negatively. That there is some underlying corruption in the system. And let me tell you, the juvenile judges that I know, they do it because they love the job. The attorneys I know that do it, they do it because they love the job. I mean, I have seen bad attorneys. I've seen bad judges. I've seen all these things. But that's the minority. When we put this kind of information out, are we working toward a good end? Or are we undermining what we're trying to do? That's what I'm suggesting. What are your thoughts? Yes, sir.
I think we saw the problems as being fairly widespread and not just simply exception to the case. And, part of the information I'm providing to students will be cases in which I've removed all the names and everything, but it indicates that, you have, a parent that, broke his child's wrist, involved his child in credit card fraud. The case has been in foster care for 5 years. The court has tried to send it back to Florida because I'm just assuming, even though the parents lived here, that by sending it back to Florida, it would make their case load a lot easier. I saw the lawyers show up unprepared. The lawyers were showing up asking me, where do you get your information about what's going on with these kids? And, as if they didn't know.
Okay, you're talking about an individual case. I understand there's some, but where's the empirical data? I mean, you say it's widespread. What are you basing that on?
Well, 9 members of us all really sharing our, our experience in terms of what we saw as CASA and panel members.
Yeah, I understand, and I think there are absolutely things out there that we can do to bring light that can help situations like that. I think there's an absence of data that would allow us to say that's widespread or that there is, and I think when we make statements like this, we got to be real careful with how we make them. Yes.
And I agree with you. I've done this for a little over 15 years now, and we're lucky that our court is kind of collaborative and we are able to work together. We have issues, don't get me wrong, but for the most part, and Dawn and I were just discussing this morning, most of us are there because our heart's in it. You don't want to see this and deal with this every single day unless your heart is in it, especially for these children. So for me, yeah, sometimes when I see that or hear people say that, I feel like, saying that we're all doing something wrong. And I don't think that. I think we have issues that need to be worked out, and we're not always on the same page. But I feel like, especially with our court, that for the most part, we're there for the right reason and we're fighting for these kids.
Anybody else want to weigh in? Okay. Once again, the whole point here, it was framed in an individual case that was come out, and that was kind of the driving point, I understand, from talking to several of the members there. And there was an editorial about a specific case, and that editorial was very critical of the court, very critical of DFACS in there. I'm not saying it might not be justified in some cases. What I'm suggesting to us is that we need to be very careful about how we talk about this. Because I don't find, personally, I don't find that it is the majority, that there's this majority widespread corruption. There are some places where we need to improve. There's places where all of us can work better, where the system can work better. But I want us to be careful how we frame that. I welcome the ability to get light on it, to bring it to the public's attention. But let's be careful. And I said this earlier. I think we're kind of the guardians and stakeholders of our system. Let's don't delegitimize what we do in arguing about something like this. Let's talk about it in a healthy discussion, so that we can make ourselves better. Anybody want to weigh in on that? That's kind of where I was at.
Yeah.
Yes,
well, while she's getting it,
Go ahead.
I mean, I would, there was no suggestion of corruption at all. I mean, I think we're all human. I'm going to make mistakes. Any given judge is going to can make mistakes on any given day. We take the information that's before us. We we can struggle with it. Sometimes cases are extremely clear-cut. In fact, I would say a lot of times it's very clear-cut. Sometimes it's not. Sometimes folks work case plans and do what they're supposed to do, and you still worry about whether a child is going to be safe at home, and they need to go home anyway. Because, I mean, we're talking about people's lives, and we're talking about people's rights to raise their children, and we just we're going to do the very best we can to equip them to do that. But it doesn't mean this is not a human system. It's not. It is a human system. So, the reality is. I guess the only thing I would add to what was said is about the one particular case I think that was being discussed from Cobb, not I don't think the one you're talking about, but a different one, was Judge Stedman told us at our seminar was that her courtroom was full of people that day, that openness of the courts really didn't have anything to do with that one. So it wasn't a matter of a court being open or closed. It's just what happened, and bad things sometimes happen. So I guess that's where we conclude there.
Yes, ma'am.
Well, and you really just kind of touched on what I wanted to say, because most of the publicity that we, and when I say we, I mean the system, DFACS, probation, the court, the judges, get is negative. And hopefully the best thing that comes out of this is the positive, in that they are seeing that we have a drug court, and I think a very new drug court compared to most. If they see someone and they think, oh, this woman is addicted to meth and has lost her children, in 6 months, if they are very interested and they watch, she may have her children back, and we may get something positive out of it. It's going to be something new. Like you said, it's 27 days old, but it can be a healthy, I hate it right now. I hate thinking that I'm going to be giving information out, but I'll adjust to that. And then hopefully it'll be something that is positive for the courts, and they're not going to hear that a child died in foster care, or that, something bad happened. They're going to hear that 10 kids were reunified with 5 different families instead of the bad.
Let me kind of give you one example. When I was the lawyer for DFACS, and I would interview witnesses, and I would have some family member tell me, blah, 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 yeah. And they said, but I'm not going to be a witness. I can't tell that. And I would say, then you don't even need to tell me that, because if I can't prove it, then what good does it do for me to even know that? And they weren't going to be a witness. But you know what would happen? If I couldn't act on that and remove that child, if something happened, they would have been the first one to go to the press and say, I told them so and so and so and so. and all that bad publicity would have come out, but there was nothing I could have done, you know. So, you know, everything in black and white, everything. You know, things, sometimes you can't prove a case. You may know lots of information, but you can't prove it. And another thing that I tell young lawyers when they come in and they're surprised by what somebody just said on the witness stand because they didn't, they said the exact opposite outside in the, lawyers, are you with me on that? You know, because they said the exact opposite outside in the conference, outside. It happens all the time. You know, you got to get them on the witness stand before you find out what the last piece of information is going to be. I mean, it's just the way it is in a legal system.
Somebody else? Yes, ma'am.
I just wanted to jump in and defend Better Courts for Kids.
Oh,
no,
you don't need to do
okay, well, that really was not ever meant to insinuate corruption. It was, we ran into systemic problems that appeared time and time again. You know, constant continuances, attorneys unprepared, attorneys that showed up at the last minute to say they had to be in Superior Court and that made another continuance, guardians who had never met the children they were speaking in favor of. So it was just systemic problems that we saw that we thought overall were not helping the children, but were actually hindering.
And I certainly don't want to imply any bad. I think that was great. And when I'm speaking to the Better Courts for Kids, people that I had spoken to, that's the message I got clear. But I'd use that not to pick on y'all, but to say that's the example of kind of rhetoric. Although you mean it good, what does that say for the casual observer?
Okay, you told me to calm you down. When
calm down.
So, no, and thank you for that.
Yeah.
I appreciate that. I just want to add this. I couldn't be a judge in a metro county. I just couldn't. I would crumble. I don't know how they manage the caseload. I don't know how they manage the lawyers, because in fact where there's in every court, lawyers come to the courts, and if they have a Superior Court obligation, that's where they have to go first. We have a different luxury, or I do, because what I say is, if you're coming to my court, don't be sending me any motions for continuances, or don't tell me you're going to Superior Court, because you're not coming back to my court if you do. And so, but that's the luxury I have. They don't have that luxury in Cobb County, or they don't have it in Fulton County. They don't have it in, well, I guess in Fulton they have, and in the really big counties you have designated and paid, this is your only job, people. But we don't. But all those people have conflicts with other courts, and everybody, we're the cheap court. We're the cheap date. Nobody gets to come to, that we're the last people you get to go to. So those are conflicts that, they're dealing with that we don't deal with. And so, I couldn't be a judge in a metro court. I don't know how they handle the problems they do.
Two things on the accountability issue. One, the foster parents were supposed to be more visible in the courts, although they're not a party who can speak to close or they can be closed out because they're not a party. They have a right to be heard, and they have a right to notice, but they don't speak with party status. So I think we have to watch how the system works under this to see whether foster parents, because they can hold defects accountable. Because I've had foster parents tell me before we pushed through the bill that mandated that the foster parents be told they have a right to be heard, the problem of, well, you don't need to go to the hearing, I'll take care of it for you. And then foster parents were kept in the dark about what was going on in the juvenile court. So I think we all need to encourage foster parents to be observers.
Guess what? We're both going to be speaking at the AFPEG
Adoption Family, it's a AFPAG
conference in February.
I would urge you to invite them at all times. I believe that some of the comments made about, I've sat as counsel for a foster parent, was allowed into a TPR hearing. And I was aghast at the guardian's lack of participation in the entire hearing. And the judge allowed it. And I think I would challenge judges that you don't need better courts or anybody, any observer to point the spotlight on the unprepared attorney, guardian, or whoever. If you witness me as a guardian not doing my job, you have the ability to sanction me. And I think you sanctioned me one time, and I will either not be a guardian in your court again, or I'll sure as hell improve my doing.
Well, I wouldn't sanction you, I just wouldn't have you as a guardian.
But what I mean is, if I'm not performing in a case that you're observing, you appointed me once, and you're thinking, well, you're not going to get another chance, Jim, but on this one, I'm going to hold your feet to the fire. Can't you pull that guardian aside and give him a little talk to or something? But I don't see that happen. I saw this entire 2-day hearing go, and the guardian never asked one question, never made one statement, and the judge came around to him every time and said, guardian, what's your position on this? No comment. Well, they got paid for 2 days to sit there, and I was going nuts, just thinking that's wrong. That is an evil that we don't need to have public open courts to find out. That judge sat there and watched the whole thing, so I hold that judge accountable.
I agree. That gentleman has not had a chance to ask.
Yes, sir.
Is this a general question and answer session or only on the issue of accountability?
Whatever you want to, well, related to this whole topic of open courts.
Okay. Well, my question is related, and it may seem to be a very simple question, but with the whole issue of accountability and open hearings, does that extend to the people who are on the calendar as well, who are members of the general public? Or
people from the rest of the calendar?
Yes.
I mean, they're members of the public if they want to sit around and hear the rest of the cases.
Okay.
And they're public. People are public. Foster parents are public. Other attorneys are public. Every public is public.
Okay. Well, that's my interpretation too, but I hadn't heard anybody weigh in on that.
I think public is public.
I think that's probably the greatest public participation you're going to have most times, the people just sitting in the counter. Right? Yeah.
I'm next.
Yeah.
Yes, sir.
I guess it kind of goes in line with his, and I mean, his question is that, I know we're opening this up to the public, but honestly, I mean, like, I work out of in Cobb and DeKalb, and you still, like, where's the accountability coming from outside? Like, if you had the press present, or someone would actually can report back to the public and say, hey, this is a bad attorney, or this is a bad guardian ad litem. It's like, I guess in that sense, where's the accountability come from? Because most of the time, I mean, it's only going to come from the judges. You have a bad judge. Unless that judge is put on blast on, Channel 2 News, it won't matter if the public is sitting there and seeing it.
Well, our accountability is to the Judicial Qualifications Commission or the Superior Court judges who appointed us, or in the case of Judge Pape, he's elected. Floyd County. He always likes to get that in.
Anybody else?
I mean, that's who we're accountable to.
Anyone else?
Right?
Yes. Correct.
Yeah, I just wanted to say one thing about the accountability issue.
Is it on?
Yeah, the green light's on.
Yeah, okay.
I'm one of the Better Courts for Kids people, and we got together because of the systemic issues. And we spent pretty close to 5 years talking to everybody that we could find in Cobb County government from top to bottom, trying to address these issues, including the Judicial Qualifications Commission, and we got zero attention. And so, in fact, if there is no recourse that we could identify to try to address any of those problems. And hence, we pushed for open court as a first step toward accountability. So that was what we found, and we were pretty diligent.
Sure.
And that's a long time.
Well, you kudos for perseverance.
True.
I mean,
and you got it, so now we'll see. I mean,
I have projects of my own too that I'm working on through the
but I think
legislature.
it's sad that there is none of the theoretical checks and balances worked.
Yeah.
And so something needs to happen.
Anyone else?
Yes.
Wait 1 second.
I'm the mother of 2 boys. You can hear me?
Yeah. But
the web can't. Okay. This is just an idea more than a question, but one of the things you brought out was one of the issues that we were concerned about, and that is juvenile court is the bottom of all the rungs of the court system. And we did ask Judge Stedman how that would change, and she said that would have to be a change from the Georgia Supreme Court, I believe, or somebody there would have to, and it bothers me personally, and I think it probably bothers a lot of you, that somehow municipal traffic court is above juvenile court as a priority. And it seems to me that that's the place that the court people could actually make a difference if you would. If the clerks and the judges all were to work together on that, it might be some place that you could say, you know, these kids are more important than traffic problems.
That's right. That's right.
There has been one change, which is great, which is that we take precedence in our TPR cases, termination of parental rights cases, over all superior court matters except criminal jury trials.
Yes.
Am I right on that,
Okay.
judges? Yeah.
Well, good. And so that's a good start.
It was a good start.
And maybe, you know, maybe you need to press harder on some of the others because, I mean, it is not fair that children are less important than traffic cases.
We agree with that.
Okay.
We agree.
Thank you. Hey, make that the next better.
Yeah.
Project.
You guys are. We appreciate the opportunity to come and talk to you. Sorry we don't have all the answers about this, but you have certainly brought some things to our attention that we didn't know, and we appreciate your participation.
Perfect question, segue. At the request of the speakers, we held these till the end so that you could follow along and participate in the discussion and get these afterwards. Beautiful color copies are available at the desk. Turn in your evaluation form and you get a lovely color copy. If you need a parking ticket, also check there. And thank you, judges.